right, we'll call up now the case of Alicia Faye Baker versus the State of Florida. Counsel for the appellant may proceed whenever you're ready.
May it please the Court, Michael Ufferman on behalf of Ms. Baxter. I'd like to reserve 5 minutes of my time for rebuttal. The issue in this case is whether or not the trial judge's 20-year sentence following the trial was vindictive in light of the fact that that trial judge had extended an offer prior to trial of 11 months and 29 days in the county jail. And I submit that the question can be answered simply by looking at the trial judge's statements the day after my client rejected the judge's plea offer.
Can I jump in and just briefly,
Sure.
counsel, on preservation?
Sure.
Assuming we don't agree that a 3.800 motion is sufficient, how does the issue preserve?
There's two ways. So the fourth DCA has said that a 3.800B motion can preserve the issue. And the second DCA has held that it's fundamental error, and even though it's not objected to, it can be raised for the first time on appeal. The fourth DCA decision is Vardaman, and the second DCA decision is Mendez. And I think the states acknowledge that in their answer brief.
Okay. In your view, what's the best way to raise this issue?
I always like 3.800B motions. Number one, when it's not clear as to whether or not it can or cannot preserve it. As a practitioner point for me, I'm going to try a 3.800B just so I can make sure I try to preserve it. On top of that, if it can be resolved by the trial court at that time, I think anything that can encourage these issues to be raised and resolved prior to getting into this court, we should be able to raise those issues. Now,
that's a good logical argument, and I agree with it. But isn't there a lot of case law that says that 3800B isn't really suitable for process type arguments like this? It's really more the legality of the sentence on its face.
Mendez certainly found that. The second DCA said that you tried to raise it in 3.800B, but we don't think Jackson from the Florida Supreme Court allows that, and therefore we're still going to be able to address it because this type of issue amounts to fundamental error. I think you have your choice. The districts seem to be in conflict, and I think there's...
Well, they aren't in conflict. They reached the same result, but for different reasons, I guess, right?
They both were allowed the issue to be presented on appeal. One seemed to say, implicitly at least, that it was preserved pursuant to 3.800B. The other specifically said it's not preserved pursuant to 3.800B, but we can still address it on appeal because it's fundamental error. So, again, I submit that this court doesn't have to look any further than what the judge said the very next day. So it was March 15, 2011. The judge had offered my client 11 months, 29 days in jail. She was accepting that, and she got to the end of the colloquy, and I guess the record seems to establish that she realized for the first time that she was going to be adjudicated guilty, and that was a concern for her. So she said, I can't go forward with the deal. Now, later on that afternoon, another attorney said she'd like to still go forward with the deal. She didn't realize about adjudication, but now she's resolved that. The judge says, come back tomorrow. It's the next day's conversation, March 16th, that I think resolves this issue. The judge, in discussing this, not in the presence of my client, but with defense counsel, and apparently the prosecutor as well, says, if she's convicted, she's probably looking at prison. That's the very next day. I submit to you that's the classic definition of a vindictive sentence. At that point in time, the judge hadn't heard any of these factors that the state's now relying upon that were supposedly recited at the end of sentencing.
What was the minimum sentence reflected in her?
Under the guidelines? 33 months.
So that's prison?
That is prison.
Okay.
However, the case law says very clearly, and this is the Wilson case from the Florida Supreme Court, that although leniency may be justified by a guilty plea, the reverse is not true. And when a judge engages in a plea discussion, a harsher sentence is not justified by the exercise of the constitutional right to trial. So the baseline, once this judge offered a sentence of 1129, had to be 1129, regardless of what the score sheet was, unless the judge could base this on other factors that maybe came out later on during the process. But we know the very next day, the judge has already said.
Would that alone be a ground in your view? I remember a case with involving one of my colleagues, Jay Hall, where, and I know he always said afterwards that it's better not to say what you will do if the defendant goes to trial. I believe he's ended up saying that, I'll give you this if you take the plea, but if you go to trial, he specifically told him it would be longer, not way longer like this case, but a little longer, and he got reversed.
It's vindictive. I mean,
Are there cases like that where the judge actually says I'm going to give you a harsher sentence if you go to trial than what's on the table with the plea, and then gets reversed?
I'm not familiar with a particular case that says that, but my argument, of course, would be that fits within the Wilson test and clearly would demonstrate. I mean, that's the second factor of the Wilson test, that the alternative sentence can't be based on the exercise of a constitutional right, and that's exactly what we have here. We have the judge, not even in the presence of my client, saying that now that she's rejected the plea offer I extended to her, she's probably, more likely than not, going to get prison, whereas the offer he had extended to her was jail. And at that point, there's nothing that he could be relying upon that has changed from the previous day, other than the fact that she's now rejected his offer and going to exercise her right to trial.
So, again, I now want to move on to the two things that the state is focusing on.
Well, let me ask you, is it the statement, if they convict her, she's probably looking at prison? Is that what you're talking about?
You know, there's another statement in that colloquy that concerns me greatly, and I'll read it quickly.
Before you get to that, let me ask you a question about this.
The plea agreement was for 11/29, right? So what the judge, is it fair to interpret what the judge was saying essentially is, once the plea agreement's off the table, I'm stuck with the minimum under the criminal punishment code unless I can find a reason to depart downward?
And I think that's the problem with judges getting involved in plea discussions. And the Supreme Court didn't say it's a good idea, but they didn't outlaw it. They said we're going to permit it. However, once the judge begins that process and engages, or in this case actually offers the plea deal to the defendant, that has to be the baseline, and there has to be something else that would come out that would be learned during the trial that would justify giving the greater sentence.
Well, I'm assuming the state attorney was in agreement with this.
No, well, the record, and again, that's the other problem, and of course I've argued this, the Warner case says that we'll allow this under certain conditions. The number one condition is all discussions must be on the record, and that did not happen here. It's only through me, upon reading this and saying, oh, this is a straight-up plea, and we've agreed, Judge, that you're going to give her 11/29, and saying, wait a minute, where was that discussion? And I had to find out after talking to the attorneys and my client that, oh, the defense attorney went into the judge's chambers with the prosecutor. The prosecutor wasn't, and everything I'm saying is part of the statement of the evidence that the judge approved. The prosecutor wasn't agreeing to this deal, but wasn't going to object to this deal. And the defense attorney said, Judge, if she enters a straight-up plea, what will you give her?
See, that's my point. If the defendant didn't take the plea and went to trial, then wouldn't the prosecutor be free to say, well, I'm not buying that. I'm not saying I'm going to fail to refrain from objecting to that now.
Sure.
I mean, bets are off now. I'm not going along with that now.
Certainly, a
then
prosecutor
the judge would have been stuck with the 33 months, right?
Well, no. I think in that situation, the judge would have to say, there's something that's come to my attention that's different from what I considered when I offered you 11/29 that justifies me now even giving you 33 months, because the downward departure could be on the table here. Judge A. very good meeting. He said the other person involved in this, Timmy Johnson, is the leader. You're only the follower. You have no criminal streak. So I think the argument from the defense would be, I'm still at 11/29, and then the state's going to have to point out something that you've learned that's different from the moment in time when you, the judge, offered 11/29. That's why judges shouldn't get involved in these discussions. Judges certainly shouldn't get involved in these discussions behind closed doors and chambers when these things aren't on the record. The Mendez court said that this court can't even review the extent of the judge's involvement because there's no record of it, and that violates what Warner says. So then, again, if you look to the two factors the state is relying upon, they say that in addition to the judge finding the mitigating factors, that she was only the follower, even though the leader still got 11/29, which, oh, by the way, is the 11/29 that this exact judge had recommended that he should get and was relied upon apparently by the county court judge in imposing that sentence. And also, the mitigating factor if she was addicted to drugs. These are supposedly the two aggravating factors. Number one, age. Oh, I learned throughout this proceeding that she's not in her early 20s. She's actually in her late 20s. And number one, I submit that that's not a factor that would justify giving a sentence that's 20 times greater. But number two, the Mendez court specifically said that the factor relied upon by the judge can't be something that existed in the record at the time of the original plea offer.
Was that the only fact that this judge relied on?
That's one of two, Your Honor.
What was the other one?
Well, the other one is the motel. Let me get to that in a second. I want to go back to this age because the age is clearly apparent on the face of the record. There's three informations in this case. Under the information, or in the information is my client's name. Under my client's name, the very first thing is her date of birth. So anyone looking at the charges in this case would know exactly how old my client was. That's not something that didn't exist at the time.
So how big is the motel?
The motel, I think 60-something people in it. But so the other factor is the motel. And I acknowledge that committing this type of an offense in public where others are at risk is a factor that can be considered. I'm not disputing that. But that is also a factor that existed at the time the judge made the original plea offer. The very first sentence of
Was
the
it booked
police...
up? I mean, was it full? I mean, what was...
Well, so the judge said, I learned during this trial that the hotel happened to be sold out that night. And that's the reason that I think instead of 1129, 20 years would be appropriate, 20 times greater than my initial offer. And again, I think the factor that should be considered by a judge and is appropriate is the offense you're committing committed in a place where others are at danger. And committing an offense in a motel, certainly it would meet that factor. But again, that factor was apparent on the face of the record at the time the judge made the original jail offer. The very first sentence of the police report says this fire occurred in a motel. So the fact that the motel happened to be sold out, as I've argued in my brief, that's beyond my client's control. Should it be different that it's 20 times greater because there's 60 people in the hotel versus 10? I submit no. The factor is that it happened in a hotel at all. It put others at risk. That's something that my client could control. She can't control whether it's sold out that night or not sold out. That's happenstance. And more importantly, it certainly doesn't justify giving the sentence 20 times greater than what you had offered prior to trial.
Well, she had a decision to make to do whether to do it in one room somewhere secluded or do it in a 60-room hotel. She had that under her control.
She did, and she decided to do it in a motel. I'm not running from that. I acknowledge that doing this in a motel is a factor that a judge could consider. That's a factor that's apparent on the face of the record when the judge made the offer. The very first sentence, so you said, did she have a decision to do this in a hotel that was sold out versus a hotel that was not sold out? There, I disagree, Judge. I'm not so sure that a defendant is able to decide this hotel looks like it's sold out or may be sold out or not. The decision that she made was to do it in a motel. I agree with you. That puts others at risk. That factor was apparent at the time the judge made the initial plea offer. So therefore, and let me focus on the other factors quickly. I say I only have 3 minutes left. The other two factors, and I've kind of addressed all of them. Number one is, was the judge engaged in the plea discussion? Well, the answer is clearly yes, but we still don't know the extent because we don't have a record. And number two, what's the disparity? And I think of all the Florida cases that have dealt with this issue, this could be the greatest disparity of all. We are dealing with a case that went from 1129 all the way up to 20 years. I've cited the Longley case from the 5th DCA where the offer was 6 months in jail and it went up to 2.5 years, and the 5th DCA said that was much harsher. This is 4 times greater than that, and again, it's 20 times greater than the initial offer. And the final point I want to make is, and I don't, the state makes this point in their brief that, oh, the judge wanted her to exercise her right to trial. I think we know what the judge, I can't explain it, but the judge gave some reasons for why this case should go to trial. And this is from the March 16th transcript. And the judge says, we're going to bend over backwards to help this girl, and it's going to come back to hurt us. One way or the other, something's going to happen. I mean, she's going to get into jail and raise hell about something, and fall and hurt her back or some bullshit. I mean, I just see this coming. I've seen it happen too many times, and I just don't need to take a chance. I was doing it for you, bless your heart, talking to defense counsel. I was going to give you, defense counsel, this deal of 11 months, 29 days. The cases generally talk about a defendant in this context having a right to an impartial arbiter. I submit that there's no reasonable defendant who could hear after the fact, because my client didn't find out until I was able to find this transcript, which she wasn't even present at, and I was able to get the court reporter to make a transcript of what occurred that day. No reasonable defendant listening to a judge saying that about her would think that that was a neutral arbiter who was going to ultimately decide the sentence to impose in her case. And therefore, I submit the record clearly shows that this is a vindictive sentence, and the remedy should be to reverse. Let me spend just 20 other seconds, and I'll save 1 minute for rebuttal. The normal remedy is remand resentencing in front of a different judge. Of course, at the very least, I'd ask you to do that. The alternative remedy that I proposed is that this judge didn't allow my client to re-enter the plea. She wanted to later that afternoon. She wanted to the following day. The judge says, no, I'm not going to do it, and gave the reason I just explained. I submit that under these circumstances, the judge should have, at the very least, given her the opportunity to re-enter the plea, and that's the alternative remedy we're asking. Thank you.
May it please the Court, Meredith Hinchell for Appalachia, the State of Florida. This case is about hindsight and regret for not having taken a very, very favorable plea offer. Any showing of judicial vindictiveness was rebutted by the trial judge's reliance on facts revealed after the plea offer was made. And I'd actually like to start with addressing quickly the fundamental error, or the potential for fundamental error being found here. The Florida Supreme Court has made clear that the 3,800 motions are to be used for corrections in the order,
not in the process. Errors in the order, not in the process. To allow this to be fundamental error would be to discourage bringing up the issue right in the sentencing hearing when